Good afternoon and welcome back to the Law News Network. We are following the case of people in the state of Tennessee versus Zachery Adams, who is charged with the murder of Miss Holly Bobo, who disappeared in April 2011. He's also charged with perpetrating a murder in the occurrence of a kidnapping and aggravated sexual assault. Do not adjust your screens. Aaron Keller is sitting in the guest chair. I'm sitting in the host chair. This was semi-intentional.
Well, you know, sometimes I do sit here, and I prefer that we keep you on your toes, Ken.
You definitely keep me on my toes. Aaron, I went over this with Paul Stanley, freelance journalist that's been covering it out there. I just feel like the prosecution's gameplay in this case is, let's parade out the most despicable scoundrels that this county has to offer. Let's elicit the most glaringly inadmissible hearsay testimony about statements Zachery Adams may or may not have said, and let's just let the public's sympathy for this, you know, very pretty young blonde girl take this guy all the way to the electric chair.
I suspect in that question you tried to catch me off guard with one thing. I agree with the beginning and the end of it, but inadmissible hearsay, well, if it's a statement of a party opponent, it's in. Zach, you know, this defendant's statements are in under the rule.
Yeah, look, I'm not trying to parse the rules of evidence here, but
well,
look,
wait a minute,
it seems
I'm
the
gonna call
bulk.
you on the middle
well,
of your
the bulk.
statement.
Hold on, let me
it,
finish, Aaron. The bulk of their evidence here is hearsay testimony, statements that this guy made under the influence of drugs, maybe off the cuff to a bartender, maybe to a guy in the neighboring jail cell. This is really the extent of their evidence. A rusted-out gun that was found 6 years later with no DNA evidence, no ballistic evidence. This is really. Look, he might have done this. I'm not saying he's innocent. I'm just saying I don't know if the evidence that we've seen proves it beyond a reasonable doubt in my mind.
This case is going to test the fringes of the reasonable doubt rule. Okay, it's a high burden of proof, and I think that the state is either very, very close to it, or at it, or maybe even a little bit beyond it. But if they are beyond it, it's a little bit, because again, it sounds more likely than not that this defendant was somehow involved, okay? He was part of this group of people. I'm believing that beyond a reasonable doubt. The question is, who did what and when? That's where I get stuck, because you've got all these different players sort of pointing the finger at one another, and they all are on the stand admitting that they're lying about something or that they have lied about something in the past. So it turns into a question of how much do we believe beyond a reasonable doubt? Because saying that someone is involved with something and saying someone is guilty of death penalty eligible murder, that's another thing.
Yeah, I mean, look, I don't agree that there, I mean, look, I do agree. There is a lot of evidence that points to him. Some of the most compelling, I think, is maybe the cell phone data. You know, this is a sparsely populated county. It's not like this high population density where it could be a coincidence that he's in the vicinity of Miss Bobo. But
well, that said, is it also possible that there could be everybody in the community's cell phone is communicating with the one tower?
Yeah, well, that's the other problem.
That might be it too.
If there's only one tower there, that could be an issue too. But look, you've got this Victor Dinsmore who allegedly sold Shane Austin the gun. I mean, if you can call that transaction legitimately a sale, it was a trade for morphine pills. You've got every witness here. They're a drug addict, they're a convict, they're a prior felony offender. You know, it just doesn't, these are the least credible witnesses to have in a case.
Well, I mean, Ken Belkin's cross-examination of the witnesses from the armchair position of the Law News Network
We were doing a little mock armchair cross-exam.
Has been better than what I've seen in this courtroom. And, you know, I've been relatively clear that I think that both sides have screwed up parts of this case. You know, and every time I start writing an article about the next dumpster fire I see here, another one starts occurring on another issue. So it's like, okay, I'm sort of the belief that this defendant was rolled up in this somehow. Okay, that I'll say. I'm not really comfortable with the process that we're using to get there. The process is
that's
what's bugging
my problem.
me in this case.
The process we're using to get here, getting witnesses to cooperate, eliciting testimony from jailhouse snitches. I mean, every one of these witnesses, they've got some skin in the game. They have something to gain by Mr. Zachery Adams being convicted. And look, That's not to say he doesn't deserve to be convicted, but like you said, the way we're getting here, it's leaving a very bad taste in my mouth.
Yeah, I'm not really comfortable with the process, and I know here internally we're always back and forth about how much legal process that we want to get into, but I got to call it the way I see it. If it's a case where there are a lot of facts to argue, I sit here and argue facts. But if it's a case like this where the process might result in a outcome that just doesn't make me comfortable based on the facts we know, I'm going to complain about the process. So this is one such case, and I keep going back to this over and over and over again, but I know it's sizzling you too as well, Ken, so give me some backup where it's due. What is up with the way the attorneys are questioning the witnesses? This defense attorney should be on these guys like a pack of dogs on a maimed animal. What's going on with this?
Yeah.
You got witnesses on the stand admitting that they're lying. They're all incarcerated, and you and I both know how to drag that out for like 20 minutes if we need to. You need to drag the cross-examination of those witnesses out about every single time they've lied, when they claimed they were telling the truth, and you keep going on and on and on until the other side objects and the judge forces you to shut up. And then you still try to keep going.
You saw me sitting in the chair during the cross-examination of Corey Rivers, and I'm sitting here. This is a guy who was charged with impersonating someone, giving a false license to someone who had also been charged with other, crimes related to dishonesty. I would be hammering this guy. I would be like, so you don't place a high regard on the laws of society? And he'd be like, well, of course I do. I'm like, well, you lied to a police officer. I was like, someone who lies to a police officer clearly doesn't place a very high regard on honesty and the laws that govern our society. You just got to hammer these guys. You're a liar. You're a liar. Over and over again, you are a liar, Corey Rivers. Over and over again, Sean Cooper, you're a liar. Sean, whatever his name is, Sean Austin, you're a liar. Yeah, you're all liars. You're all drug addicts.
And you play that back and forth with their supposed proffer of telling the truth. So you sat down here and you raised your hand up, yes, and you told the judge you'd tell the truth, yes, and you told the jury you'd tell the truth. Well, you also said you lied about this. Was that, that was also a time when you were supposed to be telling the truth, correct? And you do it with these short, forced answer questions.
Zealous advocacy.
This is the point of why I'm always harping about open-ended questions on direct examination and closed-ended questions on cross. When you're on cross, you force the witness to eat his or her own words, and I don't see a lot of that here.
Yeah, I'm not seeing that. She's really, the zealous advocacy aspect of representing someone in this situation, I'm not seeing it. She's really just phoning it in. I hate to do that. I hate to poo-poo a defense attorney's tactics. We're not in the courtroom. We're not the one under the pressure right now. But geez.
Well, I'm trying to figure
out a little bit of passion.
I'm trying to figure out a reason why this defense attorney may be doing it this way. It may be because every time she gets close to making a point, the judge basically snaps her back and sustains some objection willy-nilly from the prosecution.
But you know what? Sometimes that's a good thing. Jurors don't like it when judges sustain objections and when they don't allow people to get into things that they were asking. They find that they feel like something's being shielded from them that they should know, and they don't like it. And I think it might be even to her benefit to get objected a few more times.
Yeah, okay, well, not only that, but get it on the record, because I've seen two or three things go on here where the objection wasn't even preserved, and I'm just like, you just lost a huge issue on appeal. It's happened time after time after time. No, she has preserved a couple of issues. Because, look, the bottom line is unless you object contemporaneously on the record with some authority in your favor, then the grounds for appeal just gets thrown out the window with yesterday's, diapers or whatever.
And of course, the flip side, you kind of look like a jerk objecting too much sometimes. People like, okay, one, is this objection being used to keep something from us, or is this objection just being used to disrupt the flow of the proceeding? And that's kind of something you want to balance.
Well, you do, but I think in this case the balance has just been, so far off. It's like asking a toddler on one side of the teeter-totter to go up against a rhinoceros on the other. I mean, this thing has been all out of balance. So, I mean, she's got to object to more of this stuff. Now, in my opinion, but to go to something that you said a couple of minutes ago, Ken, some municipalities are known for juries who are inquisitive and very skeptical, and I think New York City tends to err a little bit more on that side. this defense attorney may be taking the tactic that maybe everybody in this area already hates the defendant and hates her guts for defending him. So she may be walking on eggshells through this proceeding, knowing that everybody already hates her guts. And if that's the case, you know,
maybe she should have moved for a change of venue or something.
Well, she did, and they only moved it the next county over because they already did get a change of venue.
I don't think that's far enough, quite frankly.
Well, you know, I mean, I know in one of the states where I worked, if an attorney requests a change of venue, they can't request how far away they can go. I remember that in Wisconsin in the Stephen Avery trial. You know, there was and in the Brendan Dassey trial, there's a question of, okay, well, we can ask it, but are they just going to move it to the next county over, or are they going to move it way up by, you know, in another media market where fewer people have heard about the case? So, you know, look, I mean, part of me wonders if this is somewhat of a tactic to just sort of like win the jury over by being likable, but and if it was a tactic, I mean, my reaction is basically the same as yours. If it is a tactic, it's not being played off very well, because even if it is a tactic, you still got to force the prosecutor to do things like stop leading the witness. You know, it doesn't need, well, I don't know, maybe it does need objection after objection, but, you know, one or two, you know, leading the witness, Your Honor, I think would have told the prosecutor that, well, and there are a couple of them, but the prosecutors, that they need to be on their A game a little
I
bit
really
better.
think that the climate in which this trial is taking place, it's a very politically charged climate down there right now. There is such a strong compulsion on the part of the public. There's an outcry. They want justice for this woman. This is a young member of their community that was taken way before her time, way before anyone's time at that age. You know, no one should die that young. And I think there's just this palpable need for vengeance. And I think they want vengeance, and I think they're going to get vengeance against, you know, Zachery Adams, whether or not the evidence really does prove the case beyond a reasonable doubt.
That's the fear, and it's a fear that I've sat and watched go through trials before. I mean, the way to ameliorate it, in my opinion, is to, okay,
have a strong presentation of the evidence that leads you to the correct verdict.
You know, or to hold the state to its burden properly. Because where I really start to get wound up about these cases is when I'm not of the opinion that the state is being forced to its burden. You know, we just watched this trial in Barnstable, Massachusetts, the Loya case, and you were here for a lot of it, where that was zealous defense advocacy. I mean, that case, you know, there had to be some debate about whether or not that guy was, you know, criminally culpable for his conduct, or whether he was suffering from a mental disease or defect. And, you know, look, we had strong advocacy there. It resulted in a conviction, and frankly, I think it probably was a good conviction.
Yeah, I agree.
I can't look back at that case and say, gee, I wish that I knew more, or I'm not looking back at that case and saying, you know, I think that the state walked all over the defendant's constitutional rights. Like, those things make me nervous.
Yeah, this makes me very, look, that was a case with the insanity defense. So, you know, all sorts of other things come into play. The burden shifts the defense, you know, but this is just a case of...
It does in New York, it doesn't in Massachusetts.
Well, this is just a case of where, you know, did this guy do it? It's not a question of was he insane. It's a question, a legitimate question of is he guilty of these acts? And I just, the way we're getting there is it's very distasteful. Jailhouse snitches, cooperating witnesses. I mean,
cooperating
no forensic evidence.
Look, I mean, Autry. Okay, the guy's up there and he's, you know, playing aw shucks, and he's charming the jury, walking all over the defense attorney. The defense attorney's letting him walk all over her, but he's up there, you know, saying, oh yeah, I'm the one that suggested where we should hide the body because I saw some other body floating there years before. And I'm just like, hey, look, you know, you can sit here and play it off all shucks all you want, but the bottom line is it sounds like you were calling the shots in a lot of this here, buddy, and you're hoping to get off the hook by telling this version of the story.
And the other thing, they were bringing out all of these friends of his, these former friends, like, what was this guy's name? Darnell, Carl Statler, and they bring him out, and he takes the stand, and he talks about going out and drinking with Zach Adams, and how he got into an altercation with the bartender and says, oh, I'll do you, or I'll kill you like Holly Bobo, or like I did Holly Bobo, depending who remembers the events. People say things when they're drunk. If we're even putting this kind of testimony on the stand, that doesn't tell me that the prosecution has such a compelling case. You know, people say things in bars all the time. I could go out with an ex-girlfriend and take credit for murdering Nicole Brown Simpson and say it wasn't OJ, it was me. You know, and you're really going to put this type of stuff on the stand?
And you were what during the OJ trial?
Well,
like 10 years old, 5 years old, something like that?
I don't want to date myself, but I will say I was a pretty bad 10-year-old. You know.
Yeah, but you weren't in California at the
this
time.
is
So
true.
look,
I was not in California. But these types of things that people say when they're drunk or under the influence of drugs, just off-the-cuff jokes, especially in this line of work, I'm sure we make all sorts of crazy jokes about killing people.
Well, you know, look, a journalist that I worked with in upstate New York said once, yeah, journalists are some of the most sarcastic people on the planet, and to her credit, she had the right theory as to why. It's because journalists deal with a lot of really horrific things, and they develop the sarcasm as
Gallows
a
humor.
as a shield to protect their own feelings from what they have to grapple with on a daily basis. And you know, look.
So as a journalist and a lawyer, you're extra sarcastic, Aaron
probably,
Keller.
Yes. You know, and a native New Yorker, though I'm from upstate, that probably adds into it as well. So look, I mean, you know, it sounds to me like, you know, probably there were a bunch of people in this community, and I hope it doesn't come across as inappropriate, because ultimately it is. But there are probably a lot of people in this community talking about this thing, because look, you have what's been deemed as the biggest investigation in Tennessee state history looking for this woman. Everybody was probably talking about this.
Yeah, Savannah.
Everybody, not just these defendants, not just the accused.
You've got there's 7,500 people in this town. 7,500 people is not a lot of people. Chances are everybody knew everyone. You know, this is just, people are going to talk, people are going to say things, people are going to make jokes. I mean, can you imagine how many other sort of jokey comments that the investigators had to comb through just to get to these? Just to hope that maybe Zachery Adams implicated himself one night at the bar?
I would be more apt to believe, because the initial investigators were on the stand and basically said, oh yeah, you know, this was kind of like, well, they didn't say it this way, but this is my sarcastic side. It's like the line, round up the usual suspects. So yeah, that's how we started looking at these particular defendants. That's how we got to this defendant, because, you know, people were talking about him. It's like, well, that sounds like rounding up the usual suspects. Okay,
let's get all the druggies, let's get all the you know, people with criminal records, let's get them together and let's shake them out and see who comes out as the murderer.
Who wants to point the finger,
you know,
at
that's
who else,
not,
and we'll encourage it by offering immunity all over the place to half of them, or at least some promise of immunity.
Yeah, and you know, police get someone in a room, they say, hey, just tell us what happened, we know you killed her, everything will be fine.
Well,
just tell us you killed her.
That's exactly what happened with the ex-girlfriend. And I couldn't believe that she didn't get bit into a little bit more, because they were leading her all over the place on the witness stand. That's where you need to lodge the objection, Your Honor, leading the witness.
Yeah,
because she admitted that the investigators threatened to take away her child if she didn't somehow cooperate. So she had all the reason in the world to lie.
This
and I'm
is
not
what I'm saying.
She did
Everyone
lie.
has a motive to lie here.
She had all the reason to lie, and that's one of those things that I'm just like, huh? You know, I can only hope that people on the jury are being this skeptical, because if they go back there, they hash out all of this skepticism and still deliver a guilty verdict, then I'll be comfortable. But there's a fear that this is just, like I said, online, turned into a hearsay circus, immunities flying all over the place. You got leading the witness all over the place.
All over the place.
All over the place here. And the process is not letting me sleep easy. And if it results in a guilty verdict, I might turn around and say, you know, I guess I can see it, but I'm just really not comfortable with how we got there.
Aaron Keller, are we going to be going down to Tennessee to handle the appeal if this guy's convicted?
I'm not planning to. I mean, if you would like to, Ken, then, you know.
I don't know how well Ken Belkin plays in the South, just to be honest. But look, you know, I'm a big believer that the American justice system should stand for the fact that it is better to acquit someone that is guilty than to convict even one innocent person. And look, I know I'm not naive. Our justice system does not often function in that manner, but my feeling is this, as you said, this is one of those cases that is going to test the boundaries of proof beyond a reasonable doubt. And I don't know that if you're just looking at this objectively, jailhouse snitches, people, every single witness had something to gain by testifying here. Every single witness is essentially an interested witness, whether it be for a lighter sentence, whether it be for the fact that they don't want child protective services to take their child away. Each witness was threatened on some level or coerced on some level to give this testimony. That's not a fair proceeding.
Yeah, and that's a better argument about what's going on here, Ken, than I've heard out of the defense. So maybe you should get down there and do this case, because I don't think, at least as of yet, I don't think the jury's quite seeing it the way you presented it.
Well, this defense attorney better present that argument in her closing statement. Look, I'm not saying it's the winning argument, but it is a valid argument. Those are valid points. These are all interested witnesses, and she better ask for the interested witness charge to be read to the jury.
Yeah, I mean, that better be read, or again, I'm not going to feel that comfortable with the way that this thing is rolling out. So, I mean, it's
and it's not to say that we don't want justice for this woman and her family. Of course we do. But, you know, justice is a double-edged sword. How horrible would it be to convict someone without enough evidence there just because we feel bad for this woman?
Yeah, and that's another fear that I have in this one is, you know, to me, and I say this here on Law News all the time, I always feel bad for victims. When I was a street reporter, I got to know a lot of victims' family. I know what they go through. I see what they go through when they're off camera, which oftentimes tells us a lot more than how they behave on camera. And it's horrible. Okay, it's horrible. I can sit here and feel empathy and sympathy towards them, but then on the flip side, I got to look at this logically and say, is it enough to convict this particular defendant under the law?
Yeah, there's more here than emotion.
Two different functions of the brain.
Yeah, totally two different functions of the brain. And look, not to come across as a callous defense attorney looking to weasel Zachery Adams out of any criminal culpability he may have here, you know, I do feel bad for victims, and I have represented victims. You know, it's just you want the system to function effectively. And in order for it to function effectively, you need a fair proceeding, and you need a fair outcome and result.
Yeah, This case concerns me on so many different levels. We've gone over so many of them here, but you know, where do we go from here? I mean, it seems like they're just, as you said, throwing everybody who may have had some connection to this thing on the stand. I think it needs stronger defense work. It needs stronger objections, because a lot of this sounds like character evidence against the defense. It's not just the defendant's own statements. You know, they can come in. Yeah, they are hearsay, but they fall under an exception. But, you know, what are the rest of this stuff? You know, I'm just not feeling comfortable about it.
Have you ever made a joke when you're, well, you don't really drink. I don't know if the viewing public knew that. But have you ever made a joke, just an inappropriate, sarcastic joke, well, I know you have, about wanting to kill somebody? Have you ever done that?
No, I don't think I have.
You've never? I think you've made that joke about me. But you know, how horrible is it for someone to make a joke like that, and then that person ends up disappearing, or that person did disappear, and then that joke is used against them? So I don't know if we can throw this clip, but Carl, oh, I'm getting the shaking of the head.
Are we back live? I just got a note on my computer that we're back live in this case. I can't see anything in here, so you know, we've got a new witness.
We are back live.
So
okay.
We need to go.
We are going to be taking it back to the Holly Bobo trial out of Tennessee. People, the state of Tennessee versus Zachery